And then did you download the PDF file from your My Classroom on the university website? And as I said before, most of the content coming from that PDF file. And also the major assignment, then you have to read two materials, reading packet. One is going to bullpen. I think it should be on the My Classroom. And also you need to read one actual case summary, Meki-chan versus St. Louis Hockey Club. No, you have to read two materials. Okay. Yeah. So I'm going to cover especially one of the two second material, Meki-chan versus St. Louis Hockey Club during the class, because that's one of the seminal case. Okay. Sports cases rarely be filed in the intermediate level of court. A lot of people believe that sports case, if you fight during the game, during the boxing, or during the basketball game, not many prosecutors willing to file a claim for those violences. Okay, what happened is usually the commissioner, the league commissioner, going to give the fine, a lot of money, maybe $50,000 to $500,000, depending on the nature of the behavior, which is not allowed. Also, one of the worst cases, you will be suspended from whole season, or you will be suspended for 5 games. Okay? So which means most of sports cases are civil court. In Korean, 민법, civil court. And then there are two types of court, civil court, or civil law, or criminal law, criminal court, 형법 and 민법. And most of the cases in sports industry will be civil law or civil court. But some of the exceptions, like one of the instructor of Taekwondo dojo molested or sexually abused one of the student, female student, for a minor. Okay, that will be criminal law. Okay. But other than that, most of the cases should be tort law, kind of negligent law, which means what I want is not you to serve in prison. I don't want you to serve in prison for years. But what I want is I injured at your fitness club, for example, that I need you to pay my medical bills, and then also kind of economic loss because I have to miss my work. Okay. Same thing if you're driving and have an accident. Says 90% the other party's fault, and you only contributed up to 10%, right? So 2-car collision, 90% negligent the other party, you only contributed only 10%. Total medical bill is $10,000. And typically, the other party need to pay $9,000 out of $10,000, 90% of my medical bill. Then you are only 10% responsible for a whole medical bill. However, the other party going to compensate the amount of money that you're going to miss. Because I have to stay in hospital because I'm injured. So how much do I make a day? Okay, you need to multiply how much money you make a day and how many days you have to stay in hospital. Multiply. And sometimes we call it in 위자료 in Korean, but some of the financial compensation for your mental distress or psychological issues. Okay? Sometimes it's not easy to translate your mental distress or psychological burden into dollar amount. Okay? But that's what the juries and lawyers trying to figure out. How much money do you think this is going to be? Okay? How much money do the other party have to pay for it? Okay? Okay, so if you look at the week number 1, actually we didn't cover this part the other last week. So I ask you, out of your own personal experiences or some of the indirect experiences from your family members or your brothers and sisters, or maybe your relatives, your friends. Question number 1. Have you ever injured while playing sports, working out at public and or private places, school gymnasium, recreation center, fitness club, or at the competition, etc.? If you participate in one of the university sponsored event, 학교 체육대회, university sanctioned event, and if you are one of the participant or athlete of 3-on-3 basketball sponsored by or endorsed by Hanyang University, you sprain your ankle, the medical bill will be about $3,000. What would you do? Are you going to pay out of money, out of your pocket? Okay, so depending on how much it's going to cost, and then if it costs less than 10,000 won or less than $10, then okay, it's not a big deal. I don't want a headache and hassles to file a claim. I try to make it solved as soon as possible. However, it will cost more than you can handle. More than $1,000. I mean, you have some kind of bottom line. You can handle out of your pocket, or you can have your family or your parents can pay for it. However, worst case scenario, okay, you are not able to do that. Sometimes you don't have to do that because you are not negligent. So try to figure out what happened and where it happened and what you want in terms of real relief. Okay. And then if it's the case, then you can file a claim to get some financial compensation. So this is question number 1. Have you ever injured? So I want you to share your opinion, your experiences with your classmate. Okay, so I think you went to the good school because not many school administrators are aware of what happened. Unfortunately, it happened yesterday. My son, 3rd grade elementary school student, he actually burned his mouth and then on the side of the chin when he was drinking hot water. So he was sent to the hospital. So I sent an email to the president, the principal of the school. So try to explain in a nice way. Okay. So think about if you're handling all the young, especially lower grader elementary school student. Okay, you should provide some warning sign for that audience can understand easily. Okay, do not just draw a kind of a red hot kind of symbol in front of the button. Okay, so this is one of the examples. Who's responsible? Who's negligent? Did you prepare appropriately for your audiences? Symbols, warning signs should be differentiated depending on the nature and kind and size of the audiences. If I have all the elementary school students in this classroom, I have to fix all the terms and terminology and phrases because they do not understand. I wouldn't expect they understand my legal terms in the textbook. Okay, so depending on who your audiences are, I have to modify all my languages and terminologies and etc. Okay. Okay. So that's a great story. So you acted her, and then fortunately, you're about $30 or reimbursed by.
And actually, my mom really don't fault that I went.
Okay. So I think Park Jong-won, you brought up very keen issue that we're going to cover today, which is assumption risk. Assumption of risk. If you play basketball, if you sprain your ankle when you jump or when you land down, you sprain ankle, right? That's normal. Okay, that's assumption risk. If you sprain your ankle, then nobody's responsible unless you are coerced or pushed by the other player on purpose, or we call it in legal term grossly negligent. Okay, you don't have to write down right now because I'm going to show in my slide. Grossly negligent. What about volleyball? When you play volleyball, broke your finger, you are the volleyball player. That's normal. Bruise on your eyes, you're a boxer. Okay. So depending on what kind of nature of sport event you play, you participate, then there's some kind of limitation. Then you can brought this accident into the court. So that's what we're going to cover today. Thank you so much, Park Jung-won and Choi Jin-soo. Okay, this is a kind of area, broad area. A broad area that we're going to cover. I think I mentioned briefly about a couple of topics this class will cover. Can you see this slide? Okay. So number one, university leaves its current conference affiliation to go to another conference, which means big time university in the United States. When I say big time, that's the kind of a nickname of largest size of university with a big or huge football programs and basketball programs. How much do you think Stanford University bring in to school a year out of their athletics event?
What do you mean by bringing
Revenue.
revenue?
Yeah. Athletics revenue. Just think about only 3 events. Football games. How many football games do they play a year? Less than 20 games a year. Every Saturday. Some schools play on Sunday, but big time universities, major universities that you know, you're familiar with, they play on Saturday. So one conference, small conference, regional conference, consists of usually 10 to less than 14 universities. So you have to play twice per team. So you have to play probably 20 to 25 games per season. So one home game and the other away games. So some university football stadium is having more than 100,000 people. Okay, 3 or 4 times larger than Jamsil's baseball stadium. What about World Cup stadium? About 40,000 capacity. So probably 2.5 times bigger size of stadium they're playing. Especially 6 collegiate stadiums actually having more than 6-digit numbers. What about basketball? University of Florida, how many people the facility, the arena can have? 15,000 to 20,000. So 15,000 and to 20,000 people watching the game in the arena, not as a stadium, not in the stadium. I'm talking about indoor facility. Okay. First level, second, and upper level. And then luxury suite and a lot of club seat. Okay. Stanford can bring in probably more than $150 million a year. And University of Michigan, Ohio State, other major public universities bring in more than $150 million. In Korean won, probably 1,500억 won to 2,000억 won a year. Okay. Big money. So university try to join one of the prominent conferences. Some conferences bring in more money because the conferences looks great. All the best teams, best university teams in this conference, which means attract more attention from big time medias such as CBS, or depending on the sports, ABC, NBC, or ESPN, or Fox Sports. There's a major public broadcasters as well as cable TVs. They are not able to broadcast every single game occurring at the same day or same time. So university, okay, we're leaving this conference to join another conference. So that's the contract law. Everyone does the same. Okay? They're smart enough to know what's happening. So they're trying to bind certain number of universities stay within the conferences at least for next couple of years. Okay? You're not moving. Okay? If you move, the other team try to move, try to leave, and this conference will break. So nobody wants that to happen. So second, professional sports team has a issue with the salary cap in signing a player. Think about salary, a professional athlete. Obviously, they make a lot of money, significantly more money than we can make a year. Right? But think about, do you think they deserve what they're worth in the market? Some player like a Kang Jung-ho makes hit a major deal, like a 5-year deal, about $9 million for 5 years, $4 million for a contract fee, and then he makes about $1.6 million. If I assume that $1 equals 1,000 won, then he makes 16억 won a year, and then he makes 40억 as a contract fee. Okay. Some players, next, right, second best to Kang Jung-ho. Then think about how much money he can make. What about third to Kang Jung-ho? Not as good as Kang Jung-ho, but it's not worse than awkwardly worse than Kang Jung-ho. Makes how much money? Maximum salary of the new player, 2,400만 won a year, $24,000 a year. Some players makes $1.6 million, and bench player, same position, a little bit less than, little bit worse than Kang Jung-ho, makes $24,000 a year. Does it make sense? Okay. What about FA, free agency? How many years the KBO or professional Korean baseball players can become or can be eligible to be free agent? 8 years. If you graduated from university, then it will be 8 years. If you never attend college, then it will be 9 years. Is it fair? I'm the best player. I don't want to go to university or college because professional teams wants me so badly. I'm ready to play in professional level, and then I need money, right, in the situations. Only because I never attend to university or I didn't complete university, then I have to stay 1 more year. In 9 years stay in healthy condition, which means you have to play certain number of games a year for 9 years plus military service. 9 years plus you have to serve at least 21 months, right? About 2 years, 11 years. If you're super healthy and if you're never injured, continuously play 9 years after your completion of your military service, okay, you will be free agent at the age of 32. Okay, then you are super lucky and super good at age of 32. Then you will be billionaire like Kang Jung-ho. How many players try to play in KBO every year? Think about how many universities have a baseball team, and seniors, and high school seniors. Okay. Several hundred people. And then how many people will be free agent? One digit, less than 10 free agent every year. So several hundred longing for being a free agent. Okay, bright future at the age of 20. But eventually, in reality, it's not going to happen. That's the collective bargaining and contract law. In Major League Baseball, free agency is different, 6 years. And then if you make to KBA, MLB, Major League Baseball, there's a guaranteed salary. The minimum salary will be about $500,000. Okay, that's guaranteed salary. Minimum salary in Major League Baseball, $500,000. In Korea, $24,000. 20 times. In terms of ability, performance, I don't think Major League Baseball players playing 20 times better than ours. Market is different. I mean, there's a lot of complicated issues within that topic, but think about, I want you to ask yourself, they are not laborers. They don't want to stay as one of this format of belongings to the franchise for 9 years, okay, with sort of minimum salary. Okay, prosecutor charges an athlete with a sexual assault. Once again, this is a criminal law. We're trying to minimize these criminal issues in this class, because once it happens, doesn't matter regardless of sports setting or not, prosecutors going to jump in, okay, and investigate, but we do not cover as much as the other prosecutors do. Okay, and then female basketball coach at college assert that she should be paid the same as the men's basketball coach. Who makes what? Okay. Like in my position, doesn't matter if male or female. The salary will be determined by the position. Assistant professor or associate professor or full professor, and number of experiences. Okay. Equal payment. But what about in sports? Why we pay more to foreign head coach of soccer team, especially national team? Coach Hush Hiddink makes a lot of money, made a lot of money, and Coach Shtilke, he makes more money than former Korean counterpart. I don't have any number with me right now, but we know that, right? If you want to recruit international or foreign coaches, then obviously you need to pay for more benefit, at least some of the compensations, salary plus some of the perks, perkit, kind of golf season ticket, or maybe some of the some additional budget for travel, or maybe insurance policy for whole the family members, and sometimes educational fee for their spouses or their children. So if we combine all these factors, then probably I can say absolutely foreign coaches make more money. Do you think it's fair? What about gender-wise? Male coaches and female coaches. So what do you think? Or as an example, WKBL coaches and KBL coaches. Let's say KBL coach, both are males, and KBL team's coaches has 10 years of experience in coaching, and WKBL coaches has 15 years of experience in coaching. Do you think KBL's coach makes more money than KBL's coach? Or WKBL's coach make more than KBL's coach because he has 5 more experiences in coaching? Or do you think WKBL coach deserve more salary than their KBL's counterpart because 5 more experiences? Okay, so Choi Jin-soo, you're right. Because it's kind of complicated because we don't know or we don't have any exact way to estimate or measure coach's contribution to the whole team's revenue. But we can tell which teams bring more fans plus more revenue in terms of ticket sales, media sales, and merchandise sales, concession sales. Not necessarily a person with more experience deserve more revenue. That's not right, right? So we have to deliberately measure how much you contribute to bring in more money to the institution. Okay. Among the sports, baseball coaches deserve more salary than their basketball coach? Or what about non-revenue generating sports? We call it in Korean 비인기 종목 coaches. Who deserve more salary? Okay, you can compare different kind of sports. Obviously, who brings more money? If your sports do not bring any revenue or and profit, then there's no reason we pay that much money to you like other industries do. Good? Okay, so Third law all the way, assumption risk. So this is a assumption risk that Park Jung-won mentioned. A fan hit by a foul ball may not recover from the baseball club for injuries. I have so many stories about fan being hit by a foul ball. Okay. So this is assumption risk. Okay. So this is a topic that we're going to cover in 2 weeks. Okay. Assumption risk in speculative sports and trademark law. Sport business names its sports apparel with a name very similar to another product name. I went to Haeundae Sunday, and then I realized that there's a street name is Olympic Boulevard in Haeundae. Olympic Boulevard, and the one of the sauna is Olympic sauna. Olympic sauna. Do you think it's okay to do it? If you go to LA, Koreatown in LA, United States, then you will see Olympic 세탁소, Olympic laundry stores, Olympic saunas. Everybody names Olympic as one of the store name. Who believe it's okay to use Olympic right next to their title of the store? Okay, sure. Why, Chris? Okay, so Chris, you are partially right because some of the words we call it genetic, because that's not unique, and everyone have to use that word. Like Michael Jordan tried to register his one-hand dunk shot as a trademark. He said, "Oh, this is me. I created this dunk shoot," and he failed. He couldn't do it because trademark officer said, "Oh, this is too genetic. If you play basketball, You don't have to create, because many people can do it in that same way or similar way. You cannot own any form or any gesture in sports. But at the same time, this is a part of your likeness. Because when you shoot in this way, then we can tell, oh, that's Michael Jordan probably. But you cannot own that shoot. And some of the golf player actually trying to register his golf swing as a trademark. No way. Too genetic, what Chris said. But for Olympic, this is a trademark registered. Unless you have a certain region, then you are not able to use Olympic. What about the sponsors? Visa, Samsung, McDonald's, those companies pays millions of dollars. They pay more than $10 million a year, I think, for 4-year period. Why do they pay that much money? Because of the word, trademark, symbols, Olympic ring, and the word Olympic. They want to use those words and symbols associated with their product and services they're selling. Without paying certain licenses or royalty or some different format, that you are not able to use it. Okay, so for that, going back to the story, IOC actually advised them certain store, okay, should locate it right next to Olympic Village during 1984. Then they were allowed to use the Olympic because there was some special reason to do it. But other than that, they're not able to. There's no reason. Make sense? So this is intellectual property. And another example, in the 1980s, San Francisco, gays and lesbians, we call it like LGBT, right? Bisexual, transgenders. They organize kind of Olympic types of sporting event, bringing more than 20,000 athletes. They called it Gay Olympic Games. IOC wasn't happy. And then Gay Olympic Games organizing committee said, oh, we actually benchmarking the same format. Event, logistics, accommodation, all the platforms, it's very similar. And then IOC said, oh, you are not able to use it. Okay. IOC owns the name of the word Olympic. So because of that lawsuit, and the game changes to gay games. No more gay Olympic Games. But if you watch some TV, I watched the 진짜 사나이 a couple of months ago, one of the Korean military experience show, and one of the army actually had some competition. They call it ABC Olympic. So I forgot the exact name of the competition, but they uses the Olympic. So I said, oh, okay, they are not allowed to use Olympics. They didn't pay any money. They didn't contribute to any Olympic charter or Olympic movement, based on my understanding. But a lot of people kind of ignore that or not aware of the trademark law. What about the World Cup? Okay. From one of the stock market broadcasting TV show, actually there was some program, eight investors, and they're competing each other who makes more money out of the stock investment. And then the name of this program is some World Cup. Maybe I say ABC Stock World Cup. So this kind of a tournament. If you made more money, then you will survive for next round. If not, you'll be out of the game. So they said World Cup on screen. Okay. World Cup. It's not genetic. It seems like it's genetic because we use a lot, but technically not. Without FIFA World Cup, then there's no reason we're familiar with those words. Okay, contract law, tort law, Title IX. University eliminate in women's gymnastic team and the men's basketball team. So this Title IX we might cover at the last class of this semester. Gender issue. Okay, can you think about some other issues that you experience on a daily basis? Okay, military has their own legal system.
So they go to martial.
I think because certain areas actually protected by our common law or civilian court, so we actually try to respect their own governance. So that's why sometimes it doesn't make sense to our perspective, but it happens again and again because they have their own governance rules and regulations. Okay, so have you read the Anatomy of a Lawsuit? So this story, I have two different stories about Anatomy of a Lawsuit, because this story cannot tell you what to do. If you were the victim, if you were the plaintiff, in Korea, 원고 plaintiff, or if you're the defendant or 피고인, somebody trying to file a claim against you and your organization, we need to know what we have to do. The main purpose of this class is not to train you as a lawyer or attorney, but to train you as a sports manager who understand the legal situations. We call it preventive law, not as a reactive law. Reactive is something happened, then you need to react. And then you can hire attorneys outside your company or your organization. But preventive is, if we know it's going to happen or it's foreseeable, something going to happen, then you know how to prevent it from happening. Let's say I'm in charge of this class. This is broken. Okay, what do I do? This is broken. If one of my students going to sit in here, then obviously he or she will fall, maybe potentially injured. So what I'm going to do, put a sign, put a note on it, broken. Do not sit on this chair, or put it on the side. That's negligent. That's the topic, right? So not necessarily file a claim to have a compensation, but you need to know as a prospective sports manager in the future, you're going to find a job and you will be working for a certain organization. But some fans or client, customer, whatever you call it, try to file a claim against you. What would you do? You know, you have to understand the whole structures of body of legal system. Okay, so let's take a look at the hypothetical example. Who wants to read the first part? Okay, so the first thing you have to do is complaint. Okay, complaint. Written document. Today I'm going to explain 4 elements of negligence. But you will better understand when and where you can file a claim. But right now, if somebody is injured and you believe, oh, this should be responsible by the golf course owner, then you need to hire a tort attorney, then explain what happened. The attorney's job is to write a written document which is called complaint and specifically indicating what you want. Remedies, usually financial compensation, including economic loss, medical bills, okay, potential foregone income, which means the amount of money that you would make unless you were injured. So you need to include how much money you will lose. Then you need to write down specifically and send it to the defendant. Okay, second part. Choi Jin-soo, you want to read the second part? Okay, thank you, Choi Jin-soo. So if you file a claim, which is a complaint, and the other party, defendant's party, need to respond. Okay, just make sure if the plaintiff were lying or not, or exaggerating the fact or not. So there's two different ways to do it. In depositions, order testimony, because I want you to come to the court, probably the attorney on behalf of the client, and explain what happened on the oath. And then the other way, the most common way is interrogatories, just written document, usually less than 30 pages. Okay? You need to answer as much as possible, as specific as possible. Okay? Which one do you think preferred by defendant's party, between depositions or interrogatories? Order testimony versus written document. Order testimony or depositions is not preferred. Why? Money. You need to pay your attorney by hour. How many hours do you hire? If you ask your attorney to go to court to provide oral testimony under oath, okay, how much money you have to pay? $200 an hour, depending on the location where the attorney is located. In New York, you need to pay $1,000 an hour, so it will probably several $1,000 depending on the location, worst case scenario. But oral testimony doesn't matter, just less than 30 pages long. They know what to do, they know how to do it. So it's much easier for everybody, defendant and attorneys, and they prefer to use interrogatories. And then John's lawyer deposed the club's maintenance staff about the condition of the bridge and requested the maintenance record to ascertain whether the club had acted reasonably to keep the bridge in a safe state of repair. This is a oral testimony or witness, expert witnesses. I want to bring some of the involved staff or employees and ask about the condition of the bridge. Okay? Was any signal to be followed up, and then there's no signs actually installed? Then that's your fault. But if you are not aware of that potential danger, then okay. Second question, which means, did you inspect the bridge before the event? And if you did, how often and in what way? Okay. If you do not inspect, just if you observe, oh, it's okay, it looks okay, then that's part of your negligence. You did not complete your job. Okay. So that's the next thing. And often the result of the discovery lead to out-of-court settlement. Usually, one of the negligent cases, okay, there's no number, but probably most of the cases agreed on before they go into court. Okay, once again, it's not about going to prison. Okay, I assume that 30% fault, and you are 70% fault. There must be some negotiation among the attorneys or among the parties, but usually they were eager to settle out of the court. But just in case you are not happy, okay, I'm not 30% contributed to my injury, and then you keep saying that you just paying limited amount of money to me, then I'm not happy. So I can bring this case to the court, trial court. And then if you're not happy, then you can bring it to the upper level, which is the intermediate court. Okay? And then going again and again. So the second from the bottom, if John wins the case, he will collect compensatory damages to compensate him for his injury. Compensatory damages are monetary payment, once again, monetary payment for actual injury or economic loss, and may include compensation for such things as medical expenses or property damage, potential salary loss. Okay, you have to miss your job. And then this is important. If the country club was found grossly negligent, which means grossly negligent is part of the negligence, which means they knew, they were aware of the potential issue within the bridge, and they didn't do it. Okay? They didn't do it. This is a fall apart. There's just screws missing or bolts missing. What do you expect? Then there is a punitive damages. In Korean, 징벌적 손해배상. Once again, 징벌적 손해배상. In English, punitive damages. We don't, in Korea, we do not adopt 징벌적 손해배상. So if it happened, you are really, really bad. You knew something would happen, but you didn't take any action. Then we're going to charge you punitive damages, and then the amount of money will be hugely different. Some of the legal issues within Korean airline, right? Okay, so they try to fight in the United States because they allow punitive damages. How much your mental distress worth? I think millions of dollars. Okay? So that's the punitive damages. It can be millions of dollars. Okay? Absolutely. So this is an unlimited amount of money. So we call it in Korean, kind of, you need to understand this as 위자료, but punitive damages. You don't have to serve in prison, but you need to pay way over than you can do. Okay, so as an actual example, one of the Korean laundry store owner was fired because he lost $1,000 pants. Of owner of the pants was the federal judge in Washington D.C. So he wasn't happy that laundry owner lost his pants. So he filed a claim. How much? How much? More than $50 million. He said he filed a claim. I deserve more than 500억 because my mental distress and the punitive damages. So he didn't win. Actually, he lost the suit and actually dismissed the case, and because of public opinions. Think about laundry owner. He doesn't have $50 million. Too harsh on the one of the small business owner. So he actually was asked to leave the job as a federal judge. Yeah, but think about the rationale. He knows the rules. He knows the law. He's a federal judge. He's been working in the legal industry, legal system for more than 30 years. And how can come up with $50 million for $1,000 value loss of pants? Okay, because of punitive damages. Okay, so let's take a 10-minute break, and then we can continue to second page. Next page. Okay, so this is a second case. This will help you better understand the legal system. So I want you to be in the situation of both as a plaintiff, as one go, as well as the defendant, a PIGO. But I think as a prospective sports administrator or sport manager in the future, that I want you to think about how can you protect you and your organization for certain circumstances, because your job is to provide safer and better run organization. So that's the main purpose. Okay, so Sarah Jones was a high school student and in a scholastic volleyball star in Houston, Texas. While playing in a sanctioned interscholastic event, Jones attempted to spike a ball but slipped on a water puddle. Jones tore her knee ligament. She acquired over $10,000 in medical bills, missed the remainder of the volleyball season, and lost $4,000 from not being able to work, and she missed her chance to possibly receive a volleyball scholarship from the University of New Haven. So this is based on the actual case. She was a high school volleyball student, and then she actually tore her knee ligament, which causing her total of $14,000 and plus potential scholarship opportunity from the University of New Haven. In the second paragraph, after Joan left the hospital, her father set up an interview with a lawyer to discuss legal options. The lawyer was Ruth Smith, a young lawyer fresh out of law school. Utilizing her legal process, Smith saw she had a great negligent case and accepted the Joneses as a client, Jones family as a client. Both were client because Sarah was a minor, under 18 years old, and could not bring the suit herself. So minority, being a minor, which means legal incapacity. You are not able to file a claim. You need your parent or at least legal guardian. Okay. But sometimes you have to think about, you have there's an actual case I'm going to share in a couple of weeks. But one high school student went to skiing resort, and then it was a boy. He lost his one eye when he slid through the bush areas. He lost his eyes. He lost his eyes. And then the problem is, his mom actually went to ski with him, and his mom signed a waiver form, which means I'm going to give up all my legal rights to sue in terms of negligence. Something happened, but no rights to file a claim. So what do you think? So that's a minor. My mom signed a form which protected me from receiving millions of dollars for the compensation. I have to live for the rest of my life with my with only my one eye. So we're going to cover that issue later on. But think about minor. But there's some exception. If you become adult, I said, I need to bring up what I had years ago. I was a minor, and my mom or my parents were not fully aware of the situation. I'm the person who's going to suffer, not my mom. So if it's the case, you reasonably bring the case in that way, then you can bring the case as an independent, as an adult to the case for certain circumstances. Not always happening, but certain issues. Okay. Make sense? Okay, so Smith prepared a complaint. So we know that the word, right? Complaint. described key facts available to Jones and provided enough information for the opposing side to know why they were being sued. Why they were being sued. The complaint specifically identified all non-defendants, the reason why jurisdiction was proper, and a statement setting forth what remedies Jones demanded. All the way, and then along with their answer, the defendant served Jones with several discovery requests. I want to answer as much as possible, as specific as possible. What happened? The discovery request included a quest to produce all relevant documents in Jones' possession, a request for admission, etc. Jones was required to attend a deposition. So once again, deposition stands for oral testimony, which is expensive, which is time-consuming by the lawyers and the plaintiff and defendant, all of them, where she had to answer numerous questions under oath asked by the defendant attorneys. Smith had the right to request the same types of discovery from the defendant. So motion for after several months of discovery, defendant filed a motion for summary judgment. The judge determined that there were still issues of fact that were in dispute, and as such the judge denied the defendant's summary judge motion, which means they're trying to figure out, I want to close this case in favor of my part. Most of civil cases, not one party extremely negligent. In criminal court, okay, black and white, guilty beyond the reasonable doubt or not guilty. So black and white, go to prison or not. But civil court, different. Mutually responsible or mutually negligent, or 9-to-1 ratio, 8-to-2 ratio, 5-5, 50-50 ratio, or extreme case 100% negligent or 99%. So it's much easier to agree upon the result. Okay. But rarely they are not happy, they cannot give up. So they brought to the trial court. You have an option. You can bring jury, or you can continue this case in a court without bringing jury. Okay. Some emotional cases. I'm 17 years old. I lost my eyes. Okay. This is an emotional case. I try to maximize the financial compensation from ski resort from the previous case I explained to you. Okay, my eyes open, one eye is open. Jury will be affected by my physical condition. So this is an emotional case. If you have that kind of situation, you need to bring the jury that will help you better decision in favor of your situation. But some of the very dry cases, IT, technological issue, okay, no jury needed. So depending on the nature of the issue and types of issue, then you can make a decision, either bringing the jury or without the jury. So jury, the last part, each side concluded its questioning and then made its final closing statement. Plaintiff and defendant, each party, as of short minute statement. The closing statement provided a summary of the fact the law espoused by each side during the trial. The jury awarded Jones $14,000 for extra damages, right? $14,000. Medical expenses and lost wages, and $40,000 for pain and suffering. So this is sort of a 위자료, right? But this cannot be punitive damages, but this is a compensation for your mental stress. and the lost scholarship was too speculative. Thus, the jury was barred from awarding damages for the loss. And then the families tried to receive more money, additional money, in terms of potential scholarship opportunities from the University of New Haven. She was guaranteed to play volleyball at the University of New Haven, verbal contract, but it did not happen. Okay? So this is too speculative. We know there's a possibility, there's potential you get full scholarship, but at this point, we are not able to ask the defendant to provide that much money. So that was not included. Okay. Okay, so mechanism of lawsuit. So this is kind of summary and then skeleton of legal system. So mechanisms of lawsuit: complaint, written document, right? You have to prepare a written document. Usually this is a major part, major duties and responsibilities of an attorney that you hire. Summons, how complaint in reach to defendant. But this is the very important. Most of the case, most of the state in the United States, I think we do have in Korea, but I'm not able to access that information. But mostly 2-year window. If you have a negligent case, if you fell down during the one of the university sanctioned event and you hurt, then you need to file a claim. You need to complain within 2 years in most states. Okay. If you pass 2 years, then you will lose the opportunity to bring the case to the court. Because numerous cases, millions of cases, millions of things happening every day. Okay, attorneys and judges, they're so busy. They don't want to talk about the incident occurred 10 years ago, 15 years ago. This is not criminal law. This is a civil court. 2-year window, you miss the window, it's over. No more opportunity. So when I read one of the paper and the writing a paper article right now, but think about 2011. Shannon Stone, I just brought up this case last week. Shannon Stone was a former firefighter. He attended Texas Rangers game versus New York Yankees, and he brought his 6-year-old son at the time, Cooper Stone. And then Josh Hamilton is one of the outfielder, was an instructor to toss a ball to the fan. This is kind of a fan service. Everyone, closing inning, the ball will be asked to toss the fans. And then Josh Hamilton did it. He tossed the ball. He saw the Cooper Stone, he's a little boy, and then his father, Shannon Stone, trying to receive the ball. He tossed the ball and then was short. So Shannon Stone tried to reach the ball, but he lost balance. The front row, the handrail, is extremely awkward. This system was set in 1927, about 9-year-old law regulation, which is a baseball rule. 26 inches, about 60 centimeters. If you lose your balance, you fall down, and then imagine what happened. So he lost his balance. He tried to reach the ball, and then he over, then he could balance. So he died. And his Cooper Stone, he saw his dad die. So think about 2-year rules. And exactly 1 year and 1 day prior to that accident, another fan fell down at the stadium. Fortunately, he didn't die, but he had some fractures and sprains, issues, etc. They didn't do anything since that accident happened 1 year and 1 day ago. Okay, so Josh Hamilton was so sad. and then teams, franchises, probably negligent. When something fall down, they have to do something such as increase the bar, safety bar, or try to make an empty seat. Nobody can sit in the front row or get rid of the seat. Or you need to provide some signages, warning signages. Be careful. Okay? Do not step over this handrail, safety rail, because they know what's going to happen. So the team actually had created very good or smart, I call it cruel PR plan. Once that action happened, general manager, president, Nolan Ryan stepped up and called in media conferences, said severe condolences to the victim's family, Shannon Storm's family, media conferences, and said, trying to do the best. Okay? Not, coming this from this kind of incident happening in the future. Whatever it costs, they'll do everything they can do. And then at the same time, they try to contact the Shannon Storm's family. Try to give some money, $1 million. Okay, so this is our money. Trying to help your family. Okay, and then interestingly, the families contacted by lawyers. This is obvious. Great chance of winning this case. The teams continuously contacted his family, and Texas Rangers, fortunately, in that same year, went to the playoff. So September 30th in 2011, Nolan Ryan, the club president of Texas Rangers, invited Cooper Stone, 6-year-old son of Shannon Stone, who died, and his wife, Jenny Stone, and then provide the opportunity. Okay. Game starting pitch opportunity to Cooper Stone. A lot of media plays. And then next year, they made a statue featuring Shannon Stone and Cooper Stone at the stadium. Big statue. And then they guaranteed to provide, initiate the funding for his family, especially Cooper Stone, up to $1 million fundraising for Cooper Stone. And then now they don't do anything because 2 years passed. This is my personal opinion. I believe after 2 years, the window is gone. No more chance to file a claim. If they file a claim, this will be probably millions of dollars lawsuit. And then after 2 years, Shannon Stone, the victim's father, actually interviewed with the media. We didn't want to file a claim against Texas Rangers because Texas Rangers did a great job in terms of PR, personal relationship with the victim's family. But right now, I don't think they would do something after 2 years, because 2 years, this is one of their bottom line. Try to protect them, file a claim. So 2 years. Okay, answer, deny, admit, counterclaim, jurisdiction. So jurisdiction, if it happened, then you need to determine which state, which county you want to bring the case to. California state or Arizona state. Yeah, you can choose it. Yeah. Absolutely. So you have an option, and you have a California state driving license, and then accident occur in main state. So you can bring in either state. Okay. But you need to consult with your attorney because different states have different regulation, and sometimes you're trying to find the easy way, kind of loophole, get out of that that issue as soon as possible. Okay. And discovery interrogatory, once again, written document under oath, not expensive, ask as many questions, but usually 30 pages long, but maximum 40 pages. Refuse to answer if you don't want. Deposition order under oath, the same thing, but expensive. 2 lawyers and transcript. Ask questions anyone who is involved, expert witness. And jury, so you have an option. Use jury if the case is with regard to personal injury case or anything with emotional relation. Don't use jury if the case is so dry, okay? Not emotional. Okay? There is no reason you bring the jury because you need to pay out of your pocket. Okay, trial. Okay, opening statement, direct examination, closing statement, summary, and then if you're not happy, and then bring it up to the upper level. Federal court, district court is a 지방법원, right? Same way, district court, and circuit court of appeals. So this is your 연방 고등법원, and the U.S. Supreme Court, 연방 대법원. And the same thing, state, kind of similar way but different term. Trial court, intermediate court of appeals, and highest appeals court. But you don't have to worry about it because this is a 2 American specific system. But I want you to understand the whole scenario, whole system. I think we do have a very similar system here. Yeah.
What is considered strong between introductory and you can choose between them?
Federal and state.
The discovery.
Oh, interrogatory and deposition. It's up to you. Yeah, but usually the attorney going to prefer interrogatory. Yeah, they multitasking people, so they are busy with several cases they're actually working on, so they don't want to go to court for your own case, depending on how much money you can pay. But most of the civil cases, they just want to save some time, and then they can make the written document prepared relatively for a short period of time. Good. Okay, so this is one of the practical way to attack the case. When you hear some cases or hypothetical cases, I want you to think about these 6 things. Parties. Number 1, parties. What do you mean by parties? Who are the plaintiff? Who are the defendant? Who are the pico and who are the won-go? Second, basic issue of the case. What happened? Basic issue. What is important? Number 3, object. Object. Were you hit by a foul ball, and foul ball will be the object. Number 4, defenses. So as the defendant's position on behalf of defendant groups, you need to provide, how can you say, what would you say? How can you get away out of this case with minimal damages to you and your organization? But that's what we're going to cover. I'm going to tell you some of the defensible options. And places, the location. Number 6, relief desired. That's evident. Relief. What do you want? Money. Compensation, financial compensation or monetary compensation in terms of medical bills, economic loss, and if it applies some potential punitive damages. Okay. So these are some of the scenarios. Big Mucky Mop, the Giants dog, the team mascot for the Seattle Dogs, was up in the stand entertaining the spectators with his antics. When one of the spectators seated on the third baseline was hit in the face by a batted foul ball that he did not see coming because he was watching the Ducks' antics, his eye socket was shattered, resulting in $25,000 in medical expenses. According to Bloomberg Business surveys, every year in Major League Baseball, about 1,750 fans were hit by foul ball or batted ball or broken baseball bat particles. 1,750 fans. This is exact number from the document, which is more fans hit by foul ball than baseball. The hitters were hit by pitches, and 2 fans out of 3 games. 2 fans every 3 games were hit by something, some particles, balls. And then I just read an article this morning. Okay, what's the name of stadium? One of the major stadium in the United States, about 41,000 capacity. Only 5,000 sit, protected by safety net. Okay, I'm sitting right behind the dugout, and then I know this is expensive seat, but I want to be protected. But think about only 5,000 sit out of 41,000. So what about the other 36,000 fans? Do you really care about the fans? Okay. And many fans actually hit by foul ball and then lost their eyes, broken their head, the fractures, brain damages. So what are the legal issues involved here? So 6th question. I want you to think about 6th question. You are the fan, and the mascot actually trying to entertain the group that you're sitting in. Okay, you're so happy, right? Okay, you're just having fun with the mascot, and then you didn't realize that there's a ball coming toward you, and then you actually lost one of your eye socket. One of your eye sockets shattered. $25,000 expensive. Number 1, who are the parties? Or the plaintiff, once again. 원고, who is the 원고? Fans? Okay. What if the fence is minor? Okay. If the fence is under 18 years old, then parent or legal guardian should file a lawsuit on behalf of a minor child. What about the defendant? Yeah, here's a tip. When I ask who the defendants are, you need to list every single person or organization as much as possible. Okay. Okay, the player. Okay. Okay. Manager. What about the mascot? Okay, dog. Okay, mascot. And the player and the manager. What about the team? This is quite important. In legal issue, the organization or institution can be considered as defendant, especially in civil law. I want you to pay, but most of individuals, unless they are billionaire, Bill Gates or Mr. Lee, the owner of Samsung, not many people can be able to pay for my serious issues with my eye. So most of the cases, the company, entities, organization will be the sole defendant. Okay. Trial court. Okay, I'm gonna bring every single responsible person or people or organization, and then in the meantime, okay, I don't want you to be here. Okay, you don't have money. Okay, and then who else? The organization, okay, will be sole defendant. So in this case, if I were the plaintiff, probably I'm going to file a claim against the owner of the stadium. Owner of the stadium, okay? And then maybe the owner of the franchise. Okay? And the basic issue of the case. What is the basic issue of the case? Okay, and then what happened actually? What happened? Okay, lost your eyes because of mascot antics. Okay, object. Okay, batted ball. That's important. Balls and batted balls is different, right? Batted balls. And then what about mascot antics? Some kind of sticks and gadget that mascots actually bring in. And what about defenses? If you are the owner of the stadiums and the franchise, the club, what would you say? How would you say you are now responsible for loss of your eye socket or shattered of your eye socket? We can pay $25,000. Okay. Unfortunately, the fans never won these similar cases in Major League Baseball in America because of typical, commonly we call it baseball rule, or legal standpoint, I can say limited duty rule, which means we actually offer the safe seat in the stadium. You voluntarily chose that location. From the previous case, 5,000 seat protected by safety net. You had an option to buy the seat there, but you voluntarily save some money and sit in the other side, third base line in this case. So baseball rule adopted by the court years ago, since 1917, since 1970 for the last 98 years, no fans won in these similar cases because of unique nature of the American law. American law is a common law system which is a collection of case studies, case law. So once this case has been the precedent, then the similar cases or same case should follow this direction. Okay, so once again, since 1917, nobody won because of limited duty rules. Another aspect, the back of the ticket says all the risk will be assumed by the fan at the venue. So you are assuming potentially hit by a foul ball or batted particle or broken bat at the venue. That's sort of assumption risk. You have to assume the danger. I believe limited duty rule protect absolutely the owner of the franchise and owners of the stadium. I don't believe it's fair. It's just time to bring up that issue and then revisit the case. Okay. So last issue is in the nature of baseball game. They are not able to protect all the safety net throughout the stadium. 41,000, first level, second level, and third level. The design of the stadium. How can you install all the net throughout the stadium? That's ridiculous. And also, some groups of fans complain. bothered by the safety net. I don't want to be bothered by safety net. I want to see the game without any obstacles. So there's some okay, because of that reason, no one actually won the case. That is the baseball rule. Okay. I'm going to start my lecture then. Any questions so far? Okay, negligent participant liability issue. So we're going to talk about as a player, as an athlete, or as a playing participant in the sporting event. Then what we have to do as a plaintiff as well as a defendant. So do you have to clarify one more time between spectator sports and participant sports? No, not necessary. Spectator sports, professional baseball, football, basketball, etc. You pay to watch. Participant sports, you voluntarily play in certain leisure activity. Okay. So your viewpoint, you are the supervisor of employees and volunteers who will oversee the middle school children ages from 10 to 13 at a summer camp. Because camp participants will change on a daily and weekly basis, no set sport teams will be established. So you are in charge. And what procedures will you put in place to ensure a fair and informed matchup of opponent each time teams are put together? So as a supervisor and also as an instructor of summer camp, your target audience is from 10 to 13 years old. Okay, somebody hurt. This is a negligent issue. Their parents are not going to stand back. They're going to take action against you and your organization. And then you have to be smart enough to categorize your audience's skill. Let's say this is a basketball camp. 25 kids sign up for your camp. What would you do? How can you segregate those groups based upon? All different kind of kids. Some are probably have some disability, autism, like a 자폐증, right? Or physical or mental disability, maybe one or two. Or some of them must be super good. Some of them just beginner. Or some of them never played that sports before. Different skill level, different physical conditions and mental conditions, maybe different ages. So this is a 10 to 13 years old. Everybody in this one group. Okay. And then you need to prepare some legal document. Anyone? So I would say I'm going to give them some blank paper. I want you to write down your name, your physical condition, your skill level, okay? Anything specific that I should know as an instructor or supervisor. Okay? So this can be as a secondary document when you are brought to the court, saying, I did my job. Okay? I tried to understand my audiences, what they do, who they are. what they're expected this class. So what is a negligent liability? Negligence. So first, below the standard established by law for the protection of others against unreasonable risk of harm. Unreasonable risk of harm. Once again, this is just kind of differentiated from the word assumption of risk. I can handle that if I sprain my ankle when I play basketball, but if I broke my hand while playing basketball, it can be unreasonable risk of harm. Okay? Some other reason, there must be some other reason. So it is an unintentional tort that injures an individual in person, property, or reputation, and no punitive damages may be awarded. Once again, negligent per se, negligent, pure negligent. When you practice, when you try to shoot around at 7 a.m. in the morning at the gymnasium downstairs, and then whoever responsible for that gymnasium, maybe janitors, 청소하시는 아줌마들, or some other responsible person, they need to mop up the floors. There can be water puddles on the floor. Okay? But you didn't know. You just assumed that, oh, somebody going to mop up, or somebody should have mop up and clean the floor, and you practice, you shoot around your basketball, and then all of a sudden you fell down because of the water puddle in the floor. You didn't realize, and then you sprain your ankle or you hurt seriously, and then university will be liable potentially, or janitor, or who other personnel responsible in that location, because they have a job, they have a duties, but they didn't do their job, and somebody's hurt. Then we can say, oh, there's a negligence can be established. Okay. So there's a 4 elements of negligence. 4 elements of negligence. Number 1, duty. Duty of care. Okay, I'm going back to. I'm going to use the PDF with the example. So I'm going to use the PowerPoint. However, at the same time, I'm going to use example in the PDF. So I want you to look at the PowerPoint slide and the cases. Duty of care, page number 14. Let's assume that 2 strangers pass each other on a trail in a national park. One of the strangers steps up on the edge of the trail and begins to slide down a steep slope. Will the law impose a duty of care on the second stranger to help this person who is in peril? Who like to hike? Who like to hike? Okay, so if you're hiking and then there's a unknown, a stranger who is in danger, asking help, okay, what would you do? Would you? Okay. Okay, that's a good question, because that's the Good Samaritan statute. Good Samaritan statute that we're going to cover probably not today, maybe next week. But legal standpoint, you don't have a duty to help. You don't have any relationship. But ethical standpoint, good citizenship, you were educated to help each other. Okay, we were educated. Or if you happen to see somebody who is in danger, then I definitely call 911, or I have to stand by until 911 arrives. Okay? Because if you call 911, they don't want to leave. They want to stay because they're actually tracking in terms of your GPS, your cell phone in the GPS. But legal standpoint, there is no duty of care. So duty of care indicates that you have some special relationship with other party. Some other party, special relationships. As your owner of the fitness club and the client or customer of the fitness club, that is a special relationship. Or duty of care as an instructor. I'm the instructor of this course. Okay? And then this is a part of my responsibility as an associate professor here. How do I know? My contract with the university, that's a legal document. If I have to miss a class, then I have to provide some other makeup courses. Okay, university required. Legal document, duty of care. If I cancel classes again and again, I'm negligent, and then you have a chance to file a claim against me, saying I paid this much tuition and fees, I deserve certain number of classes from this class, and Dr. Park was negligent. So first thing you have to understand that duty. Do I have a duty to teach? Okay, yes. Okay, that's the first thing. Number two, breach of duty. Defendant has failed to meet standard of care. What the provider did or did not do to protect the individual was not in accord with the standard of care. So if I know I have a duty, this is my daily job, teaching. But if I don't teach, that's a breach of duty. That's obvious. What's your job? You are the student. You're taking certain number of classes and you miss the class. You breach of duty. What about janitors who need to clean, who need to mop the floor at the basketball gym, and then did not? Certain day, the janitor overslept, was late, and didn't do their job. That's a breach of duty. Sometimes it's very vague, kind of gray area. Then I'm going to introduce new terminology. Prudent professional. Prudent professional. AKA expert witness. Expert witness, which means we need to bring some expert to the court. Jury are not expert in everything. So they need to understand what's happening from the expert in that area. Okay? So if the janitor didn't do their job in terms of cleaning the floor, and there's a water puddle and one of the students actually fell down and injury, then what would you do is you need to bring some other janitors and ask them, what would you do in this situation? Okay? Expert witnesses. Okay? We call it prudent professional. We actually create the third party who is the perfect, who can be exemplary in that positions. Okay? If coaches or instructor of taekwondo sexually abuse one of the student, so we can bring some other instructor in taekwondo with a similar or more number of experiences. What would you do? Okay. What would you do differently? Why did you have one-on-one interview all the time? So number three, important. We know that duty of care I have, breach of duty, I understand. However, my breach of duty causes the damages? Question mark. Not always does. Breach of duty causal relation, causal connection between breach of duty and resulting injury. Going back to the case, janitor on the water potter on the floor. I'm the janitor. I overslept. I missed my work. So definitely, I have a duty of care. I have my job, and I breach of duty. I did my job today, but that means that actually causes your injury. In that case, yes. If you did not breach of duty, if you came to work and cleaned them up, there must be no water potter. They would have avoided potential injury. Okay. But damages, actual damages or loss was sustained. No damages, no lawsuit. No damages, no negligent. Okay. You cannot file a claim where there's no damages. What do I compensate? Okay, there's no medical bill. You didn't miss the work. Okay, there's nothing I can do for you. Okay, but I just want to share one of those case for causation. Larger. Okay, so Bellinger versus Ballstein Spa Central School District. A fifth grader was playing on one-hand football at recess when she collided with a teammate as both players ran toward the opponent. So fifth grader Wang Yan was playing one-hand football. The teammate had hit the girl in the mouth and she lost 3 teeth. The girl's mother sued the school district, seriously, on her behalf because she's a minor. So her mother actually filed a claim on behalf of her and alleged that there was negligent supervision. The trial court denied the defendant's motion for summary judgment, holding New York Appellate Court reversed, which means school did not do anything wrong. The fifth grader tried to get some financial compensation, especially for medical bills, right? But the appellate court said, oh, school did not do anything wrong. Why? Rationale. The court noted that even if the plaintiff could show there was inadequate playground supervision, the negligent supervision must be shown to be the cause of the injuries. So this is the thing about the causation. One fifth grader running around, and then she actually hit the other classmate, right? And the victim actually lost 3 teeth. But even though there were more than 1 teachers, maybe let's say 3 teachers in that playground as a supervisor, there's no way to prevent it from happening. Make sense? Or similar cases, I'm the teacher, I'm looking at some other area where I'm chatting with my colleague, teacher. If this situation things happen, then there's no way I couldn't protect it because they're too fast. If I was not chatting with my colleague teacher, if I watching it, too late. He's running around and looking at and watching him. Okay, boom. Okay. So they understand that the teacher had the duty of care, and then obviously breach of duty. However, there's no causation. Okay, okay, so defenses against negligence. Defenses. Defensible option. Number one, statute of limitations. Statute of limitations. Action must be brought within designated time, especially for civil action, mostly 2 years. Most of the state, 2 years. 2-year window. Take action. Cause of action may be dismissed if the complaint has not been filed in a timely manner. We call it like a 공소시효, right? So certain number of years for different kind of cases. But civil law, usually 2 years, 2-year window. Number 2, act of God, act of God. Unforeseeable natural disaster. I have a very interesting case. Act of God, unforeseeable natural disaster. I want you to memorize in this way, exact way. Unforeseeable, a natural disaster. So this is an and condition. Unforeseeable and natural disaster. What do you mean by unforeseeable? Okay. Foreseeable means we can expect, we know what's going to happen. Unforeseeable in the opposite word. We cannot expect, such as earthquake, okay, flood, hurricane. So, okay, clear. Okay, so this is the act of God defense. The baseball coach at High River Academy is running the last practice before the playoff. He is determined to have all the players get their turns at bat. Storm clouds appear in the sky above, and there is a lightning nearby. Practice continues. The third baseman is hit by lightning and killed. Question and discussion. Does the coach have a viable act of God defense? So if you were the coach, one of the victim's family, he was killed, so he cannot bring the case. So family, probably parents in this case, file a claim against you and your school, your institution, which is a High River Academy. And then as a defendant, what would you say? Anticipate? You cannot or you can? You cannot? Okay. So lightning nearby. 천둥번개, right? 번개, right? Lightning nearby. What else? So 최진수 said this is a natural disaster, so could not expect. What else? Okay, so chance of being hit by lightning is extremely small, or okay. So do you think the coach will be okay? Okay, no negligence.
If he saw a weather forecast that he knew that there could be lightning in the place where he planned to practice that, is he
Okay, so there's some regulations. There must be some regulation. Okay, when they stop practicing, especially related with lightning. So the one word, like I said, unforeseeable natural disaster. In this case, this is actually natural disaster, lightning. Nobody can protect from lightning. No one will be protected from lightning. But if you know the cloud with lightning nearby, what would you do? That's right. So, I mean, Chejin's brought up weather forecast, but that's the one way. So major golf tournament, obviously, weather forecast is very important. Weatherman continuously report. Raining is not an issue. Lightning is an issue. All the sporting activities, recreation activities, lightning is one of the things, one of the few things you need to be careful. So as a technical way, flash to bang, right? So if you hear the flash, the bang, bam, and then you need to count 1, 2, 3, 4, and then bang, lightning. Once you see lightning and start counting, and then you stop counting when you hear the sound. And then if you count number 4 and divide by 4, so the lightning is about 1 mile away from your locations. So there's a certain guideline. If the lightning within the 3-mile radius, then you have to stop anything outside. So if you're not sure, then you're still counting, and then you will know, oh, it's getting away from your location. Okay, you just counted 4, and you counted 8 next time. You counted 12, which means lightning is getting away from your area, so you can, probably breathe at the time. But if you see lightning and then bang, okay, what you gotta do? Okay, call it off. That's enough for today. So if you want to use that act of God defense, I don't believe it's going to work. So there is some answers. No answers. Okay. Okay. So number 3, contributory or comparative negligence on part of plaintiff. Contributory or comparative negligence. But some state, 5 states and Washington DC still uses contributory, and then most of the state uses comparative negligence, including Texas state. If you contribute your own injury, then you are partially negligent on your injury. So this is we can share all the cost depending on how much contributed to your own injury. Okay, this is an example. Page number 21. Bob Bright has brought a negligent action against Rock On, a company that offers indoor rock climbing instruction. Bright suffered a fractured leg while he was climbing the wall. Bright failed to follow some of the safety rules that were explained to him prior to his climb. The jury heard all the evidence and decided that Bright failed to act as a reasonably prudent plaintiff in violating safety rules, and that behavior in part contributed to his injury. The jury also decided that Rock On was also negligent. The jury heard evidence relating to damages as well and ascertained damages should be $100,000. So think about, if the manager or administrator of one of the fitness club and one of the client wouldn't listen to, there's a rules. If you want to use this bench press, you have to read the instructions, step 1, step 2, step 3. And you didn't listen, and then you actually injured yourself because you listened to. We warned you, but there is no way we force you to read instruction because you are the adult. We're just telling you what you have to do, but it's totally up to you whether follow the direction or ignore the direction. So if you heard and total cost was $100,000, question and discussion, if the injury ascertains that Bright was 60% responsible for his own injury, what amount of damages will he receive? $40,000, technically $40,000. That's the rationale of comparative negligence. Then what is the contributory negligence? This is from the old fashion. More and more states try to adopt comparative negligence from contributory negligence, which means if you contribute to your own injury more than 1%, okay, then you are responsible. This is a somewhat irrational, old-fashioned way. Okay. Rock on, just 1% or 5% negligent. You are negligent 100%. Rock on, if the state adopt contributive negligence, and then Bright never going to receive $40,000 because he's contributed to 60% of his own injury, then he's not able to get those money. But comparative negligence is more rational. Okay. Same thing in automobile incident. Two parties, okay, 40% negligence, 60% negligent. If you ignore, if you did not stop the stop light, red light, and then you hit one of the stranger, the person who was in the street, then probably 90% and to 10%. But if that state adopt contributed negligence, then he won't be able to get any money, any compensation. But you don't have to worry about the contributory and comparative. I want you to understand the whole notion of comparative negligence. So in your textbook they call it, this is a secondary assumption of risk. Secondary assumption risk. The first assumption risk is that I can assume the potential danger, potential risk within the activity. I know I can break my finger when I play volleyball. That's the first assumption risk. Okay? But secondary assumption risk is that I assume I'm going to read all the instructions. I'm going to follow the direction. I'm going to listen to what instructor says. That's the secondary assumption risk. I assume that you're going to follow the direction. That's the secondary assumption risk. And then number 4, assumption risk by plaintiff. Assumption of risk by plaintiff. Okay. So page number 19, it has an example. Skydiver breaks his ankle upon landing in a field. So skydiving, when you land, when you break your ankle, that's the nature of the event, right? So this is an inherent risk of skydiving, inherent risk. So that's the nature of the risk, right? Inherent risk of the sport. What about rock climbing? Okay, you can fall down. You can fall up the cliff. That's the inherent risk. What about skydiving? Heart attack. Okay, that's the inherent risk. Since some impact with the ground is both obvious and necessary for the activity, there is no way to make the landing without risk. Sometimes the force of landing may cause a broken or sprained ankle. For example, Likewise, perhaps the wind comes up suddenly after the jump is made and skydiver is injured because he cannot avoid a tree. This is a risk inherent in the very nature of skydiving. So this is a first or just generally speaking assumption risk. Why you can and how you can be injured while doing some unique activity. Questions and discussions. If a skydiver is killed because of neither of his parachute opened, is the failure of parachute an inherent risk? When you do skydiving, do you assume, oh, what if my parachute wouldn't open? Do you assume that when you bungee jump, oh, what if this rope cut off? Do you assume that? Is that nature of the event? Is it normal when you bungee jump, the rope is cut off? Company exception? Oh, sorry. But it happened actually a couple of years ago, not in Korea. There's one bungee jumper fell down. He jumped and rope cut off and hit the ground. He died. So I want you to think about two different assumption risks. Assumption of risk of the activity first, right? So when you land, you can sprain your ankle or you can have a broken ankle. That's the nature. Not special. Many people hurt. But if your parachute wouldn't open and you die, then this is the case. It's not normal. Okay? Then you can file a claim against parachute manufacturer. Nobody wants to assume that, oh, what if? Okay? No way. Okay. Number two, is failure of a parachute an obvious and necessary risk of activity? No. So there is your answer in the bottom of the section, right? So every single case, I provide the answer. Sometimes you don't understand what this question is, what this discussion asking. Then try to read the answer first. Try to understand the concept and notion, what this is about. This will be helpful. And then exam will have a couple of similar types of questions. Scenario, I'm going to provide scenario, hypothetical scenario, and then you have to attack the cases. And when you read this case, don't forget to answer 6 questions, such as parties, who are the plaintiff, basic issue of the case, object, defenses, places, and relief desire. So that's key 6 things you need to focus on. Okay, defenses against negligence. One more, immunity. Even if a defendant has engaged in tortious behavior, the status of the defendant is of such social importance that defendant may escape liability for their behavior. This notion actually came from England. The king can do no wrong. The king can do no wrong. That's the concept. There is no way the king make a mistake. That mentality. So all the kings will be exempt or waived from negligent only negligent. And one of the most common cases involves governmental immunity, charitable community, Good Samaritan statutes. So if government or non-profit organization promote 5K run, 5-kilometer run for breast cancer fundraising event. Okay, so somebody hurt by negligence, then your organization can use one of the defensible options, which is immunity. We run this event not to make money, but try to help the breast cancer patient. So you doing good faith. Okay. What about charitable community? All the churches and religious organizations trying to promote some of the sporting related event, and then negligent issue, okay, they can be protected. The case will be dismissed automatically. But there's a lot of non-profit organization and charitable community organization related event, then it's not easy. Compared to 20 years ago, then more and more lawsuits were brought into the court. Okay? So many non-profit organizations trying to run organize sporting event, and then many negligent issues. So court said, okay, not automatic exemption anymore. This is 2015. Even though you're running for non-profit organization event, then you need to be careful. Okay? Do your job. Do not say you will be automatically protected from potential negligence. We don't give that authority anymore because so many law cases, so many issues. Okay. What about Good Samaritan statutes? Good Samaritan statutes. From the case, two strangers, you climbing, you hiking in the mountain, and the other party is in danger. Like Chris said, okay, help. So he said he would help. Then what if you're trying to help, but you heard about CPR, but you didn't know exactly how to run CPR, and then patient, the other party who are in danger, his condition got worse because of your inappropriate CPR utilization. Okay? And then, do you think you're okay? Okay, sometimes you will be protected from Good Samaritan statutes as long as you exercise what you know, what you qualified to practice in a good faith, in a good way. If you are not qualified, if you are not medical doctors, if you are not a nurse, or if you do not have a CPR certification, then you are not allowed to do it. Okay? What you can do, just call 911 or 119. That's the best thing you can. And then you can stay with the other party until some of the medical assistance teams arrive. Okay? Because a lot of people trying to help without having appropriate knowledge, and then the patient's condition got worse in a bad way, unfortunately. And the patient and victim's family not standing by, they're going to take some action. I really understand Choi Jin-soo help me out or help my sons out. However, because of your inappropriate action, then my son, okay, permanently paralyzed. And who's responsible? Good Samaritan statutes is not anymore protect your situation and yourself, not as much as it used to. Okay, there's one more case. A freshman on a varsity football team was beaten by members of the team in an apparent initiation ritual. At the team's summer football camp, the victim's father, who alleged that the defendant should have known of the initiation and should have prevented the attack, filed a lawsuit against the Board of Education and head football coach and principal. Once again, if you believe who is responsible, then you can bring in as a defendant group. The trial court granted summary judgment. Simply, defendant based on the board's sovereign immunity and the official immunity of the head football coach and the principal. So since it's a non-profit organization, education institution, this case automatically dismissed. You cannot file a claim against employees who working for governmental immunities. Who actually gave some damages, physical damages, that might be possible. Yeah, who are not employee of this government immunity. Yeah. So, but not automatically protected by community defensible options, because so many organizations try to make advantage of being protected by immunity defensible options. So legal system try to provide some warning to non-profit organization or government immunity. You need to do as much as possible. You need to increase your safety bar so nobody can be hurt because of your negligent action and behaviors. Okay, so this is it for today, and then next time I'm going to cover violence and tort law. Violence means intentional tort, and also it will cover grossly negligent and violence, fightings among the players, and abuse of the referees or judges. So many cases you can think of. So if you see, or if you have any other stories relating to violence in sports industry, then you can bring it on. You can bring it in this class for the discussion. Okay, thank you so much, and see you next Wednesday.